Christine, your Florida family law attorney, and I'm here for one more question. Today's question is about restraining orders, or injunctions for protection. There are actually 5 different types of injunctions for protection. There's injunction for protection against domestic violence, against repeat violence, against sexual violence, against dating violence, and against stalking. But really the primarily major ones are domestic violence and repeat violence. And it's very important that when you go for a restraining order or an injunction for protection, that you know which one you're going for and you're going to be applying for. The injunction for protection is when you feel that you are a victim of domestic violence or you are in imminent threat of being a victim of domestic violence. When you go and apply at the clerk's office for an injunction and there is no cost associated with it, and you do not need an attorney to actually fill out the application. I always suggest that my clients go first thing in the morning, because normally by the end of the day, the clerk's office will take that injunction to the judge and will have you an answer by 5 o'clock that evening to let you know whether the injunction has been granted or not granted. So in order to get an injunction for domestic violence, you have to have been married or in a living relationship with that person, or you have to have a child with that person. If there has been either you have been the victim of the domestic violence, or you are in fear of imminent threat of becoming a victim of domestic violence, then you would be able to apply for the injunction for protection against domestic violence. The repeat violence, you have to have 2 incidences of domestic violence. One of them, though, has to be within the last 6 months. So if you're going in for an injunction for protection against repeat violence, and there's only been one time where he has threatened to kill you or has hit you or put you in fear that you're about to be a victim of domestic violence, then you would not qualify for the injunction against repeat violence, because you have to have 2 incidences where one of them was in the last 6 months. So a lot of times people will go in for an injunction for protection and they will say, well, back when we were first married 15 years ago, he threatened to kill me. That's not enough, because you have to have one of those incidences within the past 6 months. Within the past 6 months, if he has made threats against you, or if she has made threats against you, or if you actually have had an incident of domestic violence, then that's one of them. But you actually have to have another one prior to that 6 months. It is all right to have 2 incidences within 6 months, but one of them has to be within those 6 months for repeat violence. For domestic violence, you just have to have a relationship, whether it be living together, married, or have a child together. So once you go and apply for the injunction for protection, like I said, the judge will review the application, make sure that you qualify for it, make sure that your allegations are significant enough to qualify to put the victim in imminent threat of domestic violence, or there has been an incident of domestic violence. And if so, the judge will either enter a temporary injunction and set a hearing over for law enforcement to serve the respondent with the injunction paperwork, which will give that person notice, and then at the hearing will determine whether a permanent injunction needs to be put in place, or determine that not enough qualifies for an injunction right now, but we'll go ahead and set a hearing off for you and the respondent to come, and then we can determine based on the facts that happen at the hearing whether there needs to be an injunction granted, or determine that there's not enough for an injunction or a hearing at all. Just because you don't get an injunction or get a hearing does not mean that you still may not have been an actual victim of domestic violence. Maybe the next step is to contact law enforcement to find out if criminally there is enough for law enforcement and the state attorney's office to proceed to go after the person who you believe has made you a victim of domestic violence. Whether you go civilly through an injunction or you go criminally through law enforcement, it's also important to talk to an attorney. So that way the attorney can give you either some type of advice as to which injunction you would qualify for and exactly what needs to be written down. A lot of people think that when you go and apply for an injunction, you can just say, he threatened me, I felt threatened, so therefore I need an injunction. And that's not really enough. You really need to lay out for the judge, on this date, at this time, this happened, and this is how I felt. You really need to lay out exactly why you believe you are the victim, and that's why you are requesting an injunction for protection. And until next time, I'm Christine.